that this court cannot make declarations in respect of guidelines which are not yet in place. Counsel for the second applicant contended that this court cannot determine as a matter of law that Annexure A to the affidavit in support of the application is not guidelines referred to by the applicant. He explained that court would require evidence in order to come up with a decision on whether or not the guidelines are in place. It is clear from the first sentence of the above paragraph that the Commission, by the time of the press release statement, had not issued any guidelines. The guidelines were to be issued in due course, and the Commission was to engage with the stakeholders before issuing the guidelines. It is also clear from the statement that the detailed information is to be provided by the respondent to the stakeholders, including information on the conduct of campaigns and the polling process, among others, before coming up with the guidelines. Therefore, at the time of filing this application in court, there were no guidelines yet in place. It would be improper for this court to make declarations on guidelines which are not in existence. Accordingly, the PO raised is upheld. The preliminary objection on costs is untenable, as costs fall within the jurisdiction of court. See the case of Kabuleeta.
Press release that the Electoral Commission brought out in June shows clearly at page 4 that it is going to make guidelines after consulting all stakeholders in this electoral process. So now, if it is in the document itself, how could you come and say that now we are coming to quash guidelines, yet the document clearly shows that the guidelines are going to be made in the future? So the court has said the applicants ought to have waited and given opportunity for the Electoral Commission to make those scientific guidelines. Then if they are not happy with those guidelines after they have consulted all stakeholders, then still they can come to court.
That official document from court, I mean from the Electoral Commission. So when it says now, it first released the guideline, then later it would go to consult the stakeholders. It does not hold sense. It does not hold sense at all, and the Electoral Commission should know that Ugandans are knowledgeable, have gone to school, they should respect human rights. That is the most important thing. The Electoral Commission in this case, it is becoming a judge in its own case. So there should be amendments in the law whereby at least a tribunal, an independent tribunal, are set to always handle these cases against the Electoral Commission.